Guardianship matters. The biased judge ruling gives approval to new threats from the guardian's mother. The judge muzzles next of kin from complaining. The judge in the guardianship matter of Robert J has issued a ruling November 4th approving the sale of the Robert J's property to attorney S. Fagaro against the objection of next of kin. The judge refused to pass sanction on real estate fraud and elderly abuse allegations against Vanessa D. Taylor. The judge called the next of kin who have asked Taylor for an accounting as, quote, unfriendly, unquote. But he allowed the threats of bodily harm issued by Taylor and her mother against next of kin to go unpunished. Some had called for the judge's removal on ethics violations. It is the judge who ordered Taylor to communicate with next of kin. Now, when the next of kin does just that and communicates, the judge labels next of kin as, quote, hostile, unquote. What is the judge smoking? Well, the bias of the judge. Let's see here. Judge Walter Kropowski. He has characterized the efforts of next of kin to be kept advised as to Robert J's medical care and Robert J's residence and real property. He's characterized those efforts as, quote, hostility, unquote. And it's interesting that he would characterize those efforts as hostility because he hasn't made any comment on the threats that the guardian has made to next of kin and also the guardian's mother. And it's interesting that the judge was provided copies of the threats against next of kin, and yet he I think basically the judge approved of those threats being made because the guardian works under his authority. She's under his direction, and she also works with Lawrence and Meyerson also, who's the attorney for APS, and the guardian also works with James Boutelier, who's the attorney, the court-appointed attorney for Robert J. So Vanessa D. Taylor works with them. She has telephone conferences with them. So I just believe that it's more than likely that these people advised her to make the threats against next of kin. Now the judge is saying that he didn't issue sanction against Vanessa D. Taylor, and that he told next of kin that they would have to go to court and file a lawsuit against Vanessa D. Taylor in order to get their rights enforced. And he claimed that he told that to next of kin prior, but the order of February 3rd, 2010 doesn't say anything about next of kin having to spend any money or having to file any papers with any court in order to get their rights to be kept advised enforced. So there's no indication whatsoever that the judge ever told this to next of kin. And practically speaking, why should next of kin have to spend any money just to be given information about the father's medical care and residence and real property? Why should they have to spend money? Why should they have to file any papers with a court, especially in the case where they've already brought it to the court's attention and writing? Why should they have to go any further with that? But anyway, this just seems that this is an attempt by the judge to further curtail the rights of next of kin to be kept advised as to the father's condition. Now, unfortunately, the judge seems to be blind to the fact that he has inherent power to issue sanctions for contempt of court. That's just what a judge is. The judge has that authority, has that discretion to do that. No one has to tell the judge what to do in terms of contempt of court, and the judge already has evidence before him that Vanessa Taylor has not performed some of her duties as guardian. And the mother of the guardian was asked on November 1st, and also prior to November 1st, not to make threats. She's made written threats. And she's made so after she was told not to make threats, and after the court was told that she was making threats, she continued to make threats in writing. This coming from the mother of Vanessa D. Taylor. So I would like to say to Vanessa D. Taylor, please, please, won't you please provide the answers to the 31 questions that have been posed to you. And I'm asking you please, I'm saying please, I'm being polite, I'm being civil, I'm being friendly. Because the judge has said next of kin is not being friendly, next of kin has been unfriendly. So I think this is a friendly overture to you. Please provide the answers to the 31 questions. And of course, you know, is Vanessa Taylor going to answer those questions because we're being friendly? What's the chances of that? So, Your Honor, we're being friendly here. We're being very friendly. Doesn't sound nutty, doesn't sound crazy, does it, Your Honor? Just sounds friendly, being real friendly. So where's the answers to the 31 questions? Rather than simply answer the sparse questions and concerns, Vanessa D. Taylor, along with her mother, has chosen to make credible threats. And Vanessa Taylor acts under the authority of the court because it's the court who ordered Vanessa Taylor to communicate to next of kin. Prior to the October 2009 order of the court, there was no communication between Vanessa Taylor and next of kin. And that was the way it was. And when Vanessa Taylor was appointed guardian, actually against the objections of James Boutelier and against the objections of her father initially, Vanessa D. Taylor was appointed guardian, and the court ordered her, you must keep next of kin advised as to any matters and issues involving Robert J's medical care, residence, and real property. Now, nobody forced the judge to issue this order. Nobody was bending the judge's arm. This is what the judge did on his own. He issued an order for Vanessa D. Taylor to communicate to next of kin. Vanessa D. Taylor has chosen, for the most part, and absolutely as far as the 31 questions, chosen not to answer any questions or provide information. And so when the judge says next of kin are being hostile because they are asking for the information, well, this is just the same information that the judge had already said you're entitled to. So why would the judge in a biased manner put a label on next of kin to say next of kin is being hostile? So I think rather than act in the best interest of Robert Johnson, I think that the sole purpose of the court's order approving the sale of property is to foster the unlawful threats and threats to involve others from outside of New Jersey, imposing on next of kin a chilling effect and retaliatory effect, violating the rights to petition the government by next of kin, the rights by next of kin for redress of grievances, including the right to file suit in a court of law. Under color of law, I believe that the judge has threatened next of kin's right to dissent, while at the same time the judge has engaged in a conspiracy of silence on the rights of next of kin to be kept advised under the guardianship. The judge has been charged with misconduct, bias in the appearance of bias, failure to ensure rights of next of kin, misconduct, failure to report the misconduct of James Boutelier, Lawrence Meyerson, and Shonda Floyd, unlawfully obstructing other parties' access to evidence, engaged in telling Vanessa D. Taylor to make threats and lies, fairness to opposing party and counsel, that's Rules of Professional Conduct 3.4 violation, violating the respect for rights of third persons, and misconduct under Rules of Professional Conduct 8.4, engaged in conduct involving dishonesty, fraud, deceit, and misrepresentation. And that's our report for today, November 10th, 2010, the guardianship matter of Robert J.